And just, I think in order to save time, since I'm the moderator of the second panel, I can introduce myself, and I can request I can call on the other members. So panel number 4 for today is, I'll be pleased to moderate this panel, titled the ADR Conference, Steering the Future of Dispute Resolution in Asia and MENA. So we just talked about like the immense potential Asia and MENA has in terms of to emerge as an epicenter. Recently, post-2020, Singapore has snatched the most favorite seat of arbitration from England. So London is not the most favorite seat of arbitration in the world anymore. It's Singapore. So the business is coming towards this part of the world. And the representative I have on this esteemed panel have joined us today from various jurisdictions. From Pakistan, we have had one from Qatar. He couldn't get the visa in time, so he got skipped. The other one, and we have got the second panelist from Qatar, UAE, and Turkey. So I believe this is truly a representative panel. IG is an academician, a lawyer, an arbitrator, and an advisor to the Ministry of Youth and Sports in Turkey. I now invite the second panelist, Mr. Umar Azme, who is the registrar of the Qatar International Court and Dispute Resolution Center, Doha, Qatar, where he oversees the management of cases through the QIC DRC and serves as a member of the senior management team and the Judicial Advisory Board. And Umar is legally qualified with the right of audience to practice in the United Kingdom. Can I now please invite Mr. Khurram Khan? Khurram is a New York qualified litigator and international arbitrator, specialized international arbitration specialist based in the UAE. He has more than 16 years of experience of litigation, dispute resolution, including practicing at Baker Bott, Adel Shah Goddard, KWM, and ALN UAE. And can I now please invite Mr. Robert Sivinsky. Robert is the chair of the CIAB UAE branch, a barrister, a chartered arbitrator, mediator, and dispute board member with 35 plus years of experience in the construction and engineering industries, having initially qualified as chartered quantity surveyor, and is able to provide a unique view of the worldwide ADR arena today. Thank you so very much for joining us today. Just to start off, my first question will be from Izzy. In terms of the perspectives from Turkey, what are the major challenges faced in international arbitration in terms of energy disputes, investor-state disputes nowadays in Turkey?
Selamun Aleyküm. This is my first time here in this beautiful country. Thank you for inviting and thank you for kind introduction, Shiraz. It's a great honor and pleasure to be here and to be able to share some thoughts in this distinguished group of guests, legal experts, and friends from all around the world. So the question, what are the major challenges in international arbitration in terms of energy disputes nowadays? So the short answer there are many major challenges in terms of energy disputes. But I would like to mention some of them here. The first of all, we can call the major challenges the overpromise issues. Let me explain what I mean by overpromise issues. So in terms of investor-state dispute settlement, we know the states make meaningful promises to foreign investors in order to make a good investment climate to attract more foreign investors. Generally speaking, we can say the states may give too much to attract the foreign investors in order to meet the perceived urgent demands of increasing energy disputes, energy needs, as well as adopt the new technical equipment and knowledge. In this respect, the states may overpromise through their national energy law and regulations to make their legal environment and investment climate extremely friendly, attractive for foreign investors. However, in the other side, after foreign investors invest in these countries, because of these good and seemingly fixed commitments given by governments, states perhaps for a very good reasons changed the rules of the games after it started. So then this too good to be scenario comes to an end and can give the rise to a dispute that becomes the subject of an investor-state disputes. So this is one of the major problem we can say. But the other one is, I would like to mention here, the reputation of the international arbitration as an effective and reliable means of resolving international disputes. I remember one of my professors from Boston University, William Park, he is also very popular in this investment arbitration and international arbitration world. He mentioned it very well. Like he said that the many politicians and journalists do not really understand what arbitration is all about. So, for example, a United States senator wrote for a very major newspaper, and she attacked arbitration with a question as, so what is wrong with American courts? So we can extend this question like what is wrong with Turkish courts or what is wrong with Pakistani court that we are looking for an alternative dispute resolution. So the answer is nothing. So nothing wrong with American courts if you are an American. But if you are in Turkish and if you are Pakistani. But if you are investing in any other countries as a foreign investor, and you might not feel the same comfort level if you have to go to lawsuit in local courts. And also, the other part of this issue, the globalization, continues to drive the expansion of international trade and investment. Disputes between the parties from different jurisdictions are becoming increasingly common. The problem becomes particularly important when one thinks about the fact that there are in the world still many countries without the traditional of judicial independence. The energy sector provides a worthy and significant example of this economic globalization. However, as in Turkey we say, every rose has its thorn. A consequences of that globalization in that the legal issues and the related disputes have been rising. The recent decade has been notable for a record of number of the investment disputes, especially in the energy sector. In this context, the investment arbitration has emerged as a preferred method for resolving such disputes, given its efficiency, flexibility, and enforceability. So the discussion about the reform issues in terms of the ISDS, I will say the reform is desirable, sustainability of the system, in order to strike the right balance between the states and the related public interest, on the other hand, the investors and the private interest. So that's all in this question I could say.
Thank you so much, Aishi. I will now move on to Umar. My first question to you is, can you please explain what is the jurisdiction or the function of QIC DRC, and why has it got such a diverse judiciary?
Okay, well, good afternoon, everybody. First of all, I wanted to say thank you so much for inviting me. This is my third visit to Pakistan, and it has been a truly wonderful couple of days, and I'm sad it's going to end. But thank you all to the organizers and to everybody that's helped. There are a lot of these courts around, and I know it sometimes can be a bit confusing with these entities popping up everywhere. But I work for the Qatar International Court and Dispute Resolution Center, and I wanted to start off very briefly by explaining what we actually do, because it's not necessarily clear just off the bat. It goes back to investment and the economy. So Qatar, in the early 2000s, was deciding how to diversify its economy, and specifically how to attract local, regional, and foreign direct investment into the state, or as much of it as possible. And one of the ways one can do this is by building investor confidence, obviously. How does one do that, especially with an eye to regional and foreign direct investment? So one way Qatar did this was through the creation of special economic zones. Now, I'm sure all of you will know the broad picture as to how these zones operate, but effectively, they offer favorable ownership structures, they offer favorable taxation regimes, they offer repatriation of profits of 100% back to the home country. Now, our role effectively is to be the court, the default court for the special economic zones. So there's two main ones at the moment. The Qatar Financial Center, which focuses on financial services, professional services, consulting, and the Qatar Free Zones Authority, which is a geographically bound authority which focuses on logistics, transport, and that kind of business. Now, part of the deal for foreign investors is, well, what happens if my capital is at risk? What do I do? And that is often the very, very key question, and it's entirely understandable. And it's not necessarily a mistrust of a local system. I wanted to emphasize this for everybody. It's just simply a lack of understanding. The local Qatari system, or the other national courts, conduct their proceedings in Arabic, which is normal. It's based on civil law. So a lot of foreign investors who simply don't understand and maybe put off slightly by investing in something that they don't understand. So we offer an alternative. We are the default court for the zones. We have 18 judges from 12 different jurisdictions. We haven't simply packed our court with judges from one country. We have a very, very diverse range and a very significant number of legal traditions that come in to our judgments. We have a judge from China. We have a judge from the States, from South Africa, New Zealand, Hong Kong, Singapore, of course England and Wales, and Scotland as well. We're cost effective, we charge no fees, we're very, very efficient. Our smaller cases get through from issue to judgment in 30 days. So literally from the case being filed and accepted to a judgment being issued simultaneously in English and Arabic. Our slightly larger cases will take 46 days where there's no trial. And the biggest cases with full trials take on average 128 days to get through. And those are because you have to build in time for witness statements, disclosure, and all the things that one would expect from a very fair jurisdiction. We're very open and transparent. All of our proceedings are broadcast live on our website. The doors are open if people want to come in and listen. We have a practice direction that it allows non-parties to come and get documents from another case if they're interested. So that is part of the deal. You invest in the special economic zones, and God forbid if something goes wrong, you have a stable court that you understand. That's the key part. And it's not in any way impugning any of the other local courts. We also have Qatari judges on our bench, very importantly, and they are absolutely excellent. But it's about trying to make the place more attractive for foreign investors by providing a product they understand. The president of our court is Lord Thomas, former Lord Chief Justice of England and Wales. Our former president was Lord Phillips, of the same role, and our first president was Lord Wolfe. But we have very high-ranking judges from across the world and senior practitioners. And I haven't yet got a Pakistani judge on the roster, but it would be very nice to have one as soon as possible. So in a nutshell, our jurisdiction covers the special economic zones, which are a core part of Qatar's foreign direct investment strategy. And our view is to have a very, very diverse bench. It significantly increases the quality of the judgments. I'll tell a very quick story before I end. We had a number of cases that were heard by a Kuwaiti judge, a South African judge, and a Chinese judge. And a simple contract problem would come before them, or a complex one. They would all come to the same conclusion, but just using different routes. So it means that our jurisprudence has, juridical principles from China in one judgment, simultaneously from the Greco-Roman tradition in South Africa, and also the Islamic civil law tradition from Kuwait. And in my view, that makes a decision more strong and much more cogent.
Thank you so very much, Umar, for enlightening us with the functions and features here QIC DRC has. I will now move on to Khurram. Can you please enlighten us with what are the drivers of ADR in Asia, MENA, specifically for UAE?
Sure. Thank you, Shiraz Saab, and good afternoon to all. So this weekend we've been talking quite a bit about ADR and the interaction with courts here in Pakistan. And what I thought might be helpful is to talk a little bit about what the drivers of ADR are both here in this region and contrasting that with other regions. So if we take a look at regions such as North America, the US specifically, what tends to happen is you have a very large domestic litigation market that's very mature, which has courts that have subject matter expertise, and where the court systems have quite a bit of influence and leverage in that they can draw foreign parties into their court systems. What that then means is, from the standpoint of litigants, you have relative certainty with timescales, so parties have a sense of how long an action might take. There is some reliability or strong reliability in terms of the procedure. And there's a perception of fairness or reliability in terms of what the outcome could be. A result of that is that ADR is relegated to certain situations. So specifically, if we take arbitration in the US on the domestic front is typically reserved for either where one party has much more bargaining power or where the parties want confidentiality. And international arbitration is really there for cross-border situations. So if Samsung and Apple have a contractual arrangement and there's a fight, Samsung does not want to be hauled into American courts and Apple does not want to be in Korean courts. That's essentially what you have in a jurisdiction such as the US and I think in England and certain other places. Here, the situation is very different. In Asia and MENA, there are very different drivers for ADR. So for instance, in Pakistan, some of the discussions that we've been listening to include concerns over timescales. So often cases which would take a certain amount of time in a different jurisdiction take quite a bit of time here, even though there certainly is subject matter expertise. We've heard from justices who have considerable experience and skill. But certainly there's at the very least, there's a perception concerning the timescales. And in my more limited experience, I can say that there are concerns of cases being trapped in amber and status quo remaining for quite some time. From a foreign investment standpoint, we've talked about some of the concerns, so those are obvious. And the short point is that, again, there's a perception concern that there would be a home court advantage or a foreign party would not want to come in for a fight here. And we can extrapolate some of those to other parts of the region. So if we look at MENA quickly, so in the GCC, one of the points that my colleague Omar mentioned was the distance between the language. So you have foreign investors that might have reliable courts to take their disputes to, but the courts are Arabic-speaking courts, and for certain foreign investors, they'd rather have a dispute be heard in English. And sometimes there's also concerns over subject matter expertise in some of the state courts, although that's improving. And the advent of the court that Omar represents in Qatar, what we have in the DIC and the ADGM also represent more optionality. But the point remains that in the broader Asia-MENA region, ADR has a much bigger place and bigger role to play. And that's quite important, I think, for all of us to understand. In the UAE, for instance, domestic arbitration is very common. This is I'm sure something that Robert can also speak on. So it's not uncommon at all in the way that it is in certain other parts of the world. And so then you have regimes where the international arbitration and the local domestic arbitration are quite similar in certain respects. And then certainly other parts of ADR, whether we're talking about mediation or we're talking about negotiation, expert evaluation, or DAB, those two have important roles to play. So just to conclude on this point, I think when we talk about the role that ADR has to play, the starting point again is what what are the incentives that are driving these, and that can help us figure out the sort of shape we want these institutions to take. Thank you.
Thank you so much, Khurram. I would like to move on to Robert now. Since you're the chair of the Chartered Institute UAE branch and you have been working with HQ for quite a long time, what do you think? Is CR training is worldwide, and if so, how does it react to different jurisdictions and cultures?
Well, hopefully this is working. Thank you very much for inviting me. And Shiraz, you've got two chairs on this panel, which is very nice. I'm as was just said, the chair of the UAE branch of the Chartered Institute of Arbitrators. Now, I was asked to talk about education and ADR capacity, and the questions that have been posed are with regard to training. Yes, in the UAE, we have a lot of domestic arbitration, which is quite right, as my colleague has just mentioned. And in that regard, training locally is perfectly acceptable, so long as you're willing to just arbitrate in the local forum. For example, there's training in Arabic, and that's very useful when you have, thank you, sorry, I hope you heard me earlier. And that's very useful where you have two Arabic partners in arbitration, and so therefore you need Arabic-speaking arbitrators. Same with mediation. But of course, international arbitration, goes much wider than that. And in a sense, what we're looking at here also in Pakistan is a real backlog of cases in litigation where ADR can be helpful. How do you deal with that backlog? Well, steps are being taken to introduce ADR into Pakistan. The judiciary are supportive, the government is supportive, which obviously is a very good first step. But you need to train the ADR professionals. How do you train them? Well, there's much local training, as we have in the UAE, and that's very good for domestic arbitration and mediation. But those who wish to have a career in ADR, who wish to be arbitrators, who wish to be mediators, what should they be looking at? Because arbitration does cross borders. It does involve international parties. And sometimes it's important to be able to act as an arbitrator in different jurisdictions. Obviously, I would suggest you need to train with the Chartered Institute of Arbitrators, because that's a worldwide training. It's recognized throughout the world. And as an example, actually, which I was going to deal with a little later, some arbitral centers, such as Singapore, SIAC, will only allow you onto their panel if you're a fellow of the Chartered Institute of Arbitrators. To my mind, that's a good indication of the fact that you should be a fellow of the Chartered Institute of Arbitrators. But how do you get there? I'll keep this relatively short because I could rattle on for quite a long time about training. But you'll start as a student, of course, become interested in ADR. Some of the universities here do in fact have courses on ADR, which is a very good start. You can join the institute as a student member and obtain information and indeed be able to network with like-minded people. If you find that ADR, be it arbitration or mediation, is something that you wish to pursue, you would first put your foot in the water. Take an introductory course. The introductory course gives you an understanding to ADR, the background of ADR. How does ADR support dispute cases? And gives you the knowledge, or at least the initial knowledge, of the processes and procedures in the various forms of ADR. And of course, once you've undertaken the initial course, you can become an associate of the institute, which would be a good thing. If you find this is something you really do wish to pursue, along with perhaps your work as a lawyer in litigation, you would move on. Now, I should mention that all the courses that we run are arbitration, international arbitration, mediation, and probably predominantly for the UK, construction adjudication. And all of the various levels of training that the Chartered Institute of Arbitrators has allows you to progress to member and certainly with arbitration to fellow. And it's only at the fellowship level where the Chartered Institute and you can feel comfortable that you have sufficient knowledge to be able to perhaps act as an arbitrator. If you take the mediation course, you can get accreditation as a mediator. That's not up to fellowship, that's membership. They're working or thinking about potential fellowship for mediation. But at the moment, the accreditation will allow you to be a member of the Chartered Institute. And accreditation as a mediator is also vitally important, I suggest, to allow you to understand the nuts and bolts of what mediation is and how to be successful as a mediator. It's not simply just chatting to the parties. There's a lot more to it than that. Each of these courses gives you a clear understanding of the legal framework, gives you the best practice and procedure in each of these areas. And certainly once you've gone through the stage one, module one, which is the pathway courses, I should mention that. Module one, it allows you to be a member. Now, what do I mean by the pathway courses? The pathway courses are a route for members of the Chartered Institute to progress first to membership and then to fellowship. And of course, as I've just said, fellowship is what you're aiming for should you wish to be a practitioner, certainly in arbitration. Mediation, I should mention, because mediation is something that's very important here in Pakistan, is a skill set that is about trying to bring parties together to find a solution to their problem, their dispute. It's not about the rights and wrongs of somebody's dispute. It's about finding a compromise which both parties can live with. It's a crucial difference between mediation and arbitration, or indeed adjudication. So again, it depends on your personality, perhaps, the sort of way you wish to work, if you wanted to become a mediator, or perhaps the more legalistic side of things, becoming an arbitrator. But in any event, to become a member, you take the module one of the pathway course, which allows you, as I said, to eventually become the mediator or arbitrator as a member. A shorter route for those who are experienced is the accelerated routes to membership and fellowship. If you have experience, and you can demonstrate that you have experience, that you have the knowledge, for example, of international arbitration or arbitration, that you can show that you know how to evaluate and apply the principles and requirements of an international arbitration or ordinary arbitration, you have an understanding and show an awareness of the practical tasks required for running an arbitration, then you could take the accelerated route firstly to membership, or if you are a practicing arbitrator, for example, to become a fellow. Now, these routes are much quicker because the pathway, the modules, will take possibly 3 years to complete. The accelerated route will take a much shorter time. They're run as a single course. Membership is a 3-day course. Fellowship is a 5-day course, of which, and that's online. If you do it face-to-face, it's of course much shorter. And I would recommend you do these courses face-to-face, quite frankly. You learn a great deal more, and you've got a much higher chance of passing the assessment, which of course comes at the end of each level. So Module 1, Law, Practice and Procedure. Module 2, Law of Obligations. Module 3, Award Writing. The first two you might be able to get an exemption from, depending on your background, the legal training you may have had. Module 3 is of course compulsory. The award writing is a difficult exam. It's got a pass mark of over 70%, and unfortunately I have to say this because I do believe this should be face-to-face if you can. Because of COVID, because of online training that's been occurring, people who've been taking the award writing course, there's been a greater degree of failure. And why is that? Because they're not engaged online as much as perhaps one would like. So if you are going to take the courses online, please be engaged. I like to pass people, not to fail them. As I said, the pathway courses take up to 3 years. The accelerated routes, if you already have experience, 3-5 days if it's online. It could be a weekend if you're doing it face-to-face. We also run diplomas in international commercial arbitration, which would also take you to fellowship, and a diploma in maritime arbitration, which is not just about arbitration, international arbitration. We look at other areas as well. So that was a very quick run through of the essential Chartered Institute of Arbitration training. Other training is undertaken. For example, in the UAE, we are about to embark on training for those who are already arbitrators, fellows, for a crossover course to undertake dispute board work. So, and it's important. It's not just about a dispute with dispute boards. It's about bringing the parties together before a dispute has to go to adjudication. And there are certain skills that you're not taught as an arbitrator. So we're running a course for that because it's important in the UAE. Abu Dhabi have introduced a new construction engineering contract based on FIDIC, but it has a mandatory standing dispute board, or DAAB in actual fact. So therefore, we need to find people who can act. We're also running the mediation courses face-to-face, and one of the problems with mediation in the UAE is how many mediators, accredited mediators, do we have in the UAE? We don't actually have that many, because predominantly in the commercial world, we've been looking at arbitration. So we have put together a list of mediators that those who wish to find a mediator can consult and therefore find, hopefully, the right mediator for their problem. Bringing me back to cross-border training. Cross-border training is incredibly important, that we know that the training we get can be applied in different jurisdictions. There are certain groups, such as the Chartered Institute of Arbitrators, but the Royal Institute Chartered Surveyors, for example, ADR, ODR, which is more of a private organisation, but they deal with training that is relevant in many parts of the world. As I mentioned, for example, Singapore, to be on their panel, you need to be a fellow of the CIARB. Why am I mentioning this? Well, for those of you who wish to take this route to be an ADR practitioner, do you wish to just train domestically? If so, the local, yeah. The local, I'm being chased to finish. I'm just on my last page, we're okay. The local training, if you just wish to work in the local jurisdiction, is absolutely fine. And there's some very high-class courses. If you do wish to work internationally, or you wish to move your practice to another country, do make sure that the course you take is appropriate and that you can get on the various panels and that the accreditation you have is acceptable. Lastly, I have to congratulate Shiraz on his initiative that he introduced at the beginning of this session, bringing centres and practitioners together from different regions to try and help with not only training, but also providing the services to make ADR successful. So I will shut up there. Thank you, Shiraz.
Yeah, but thank you, Robert. Just a very quick one, and a very brief answer to like who delivers the CIARB training, and there are so many organizations that have accredited training. So what is the difference between those and the Chartered Institute of Arbitrators training?
Well, as I said, the Chartered Institute really is predominant in that it's recognized worldwide. It's considered the gold standard. If you've got to Chartered Arbitrator, for example, which you have to have quite a bit of experience as an arbitrator and prove yourself, that's definitely above the gold standard, which is fellowship, and proves your ability to anybody that you potentially might want to use you as an arbitrator, of your abilities, rather than taking a risk on someone who may not be quite as trained in that way. Fellowship is a gold standard. It's a high quality training with high quality tutors. It covers everything you need to know about arbitration and allows you to start practicing. Other institutions don't necessarily give you that, For example, in America, you've got the AAA, for example, but they don't actually train. They give courses on arbitration, but they don't actually train and give accreditation. And we give post-nominals, which allows people to see that you are of the quality that may be desired. Hopefully that answers your question, Shiraz.
Yeah, thank you. Thank you very much, Robert. I will now move on to Umar. So how does the Qatar International Court and Dispute Resolution Center approaches its constitutions?
So I can answer that fairly shortly, so I'm going to segue into something I should have mentioned earlier. If other countries are interested in looking at how we operate, I should have stressed before that we are part of the national judicial system. That is very, very important. We're not an offshore court. We are a state court of the state of Qatar, just in the way that you will have civil courts and criminal courts and family courts with special jurisdictions. We are part of that overall state structure. And what that does mean is that we see ourselves, and I hope the other courts see us, as we're complementary. We're working together in one system. We don't have conflicts over jurisdiction with other state courts. So, for example, all cases come to me first as registrar. In 2023, we had a 450% increase in the number of cases that I had to turn away for lack of jurisdiction, and those cases go to the other national courts. And I'm using the word other because we are one of them. Conversely, it happens the same in the opposite direction. If they get a case that should be with us, they send it to us. So we maintain very, very good relations with the other national courts, and there's no friction at all. Crucially, I think for people here, with clients who might be interested in looking at Qatar, we have our own in-house enforcement. So our rules explicitly give our own enforcement judge the power to instruct competent state authorities to enforce our judgments directly. We don't have to go anywhere else. And that work that we've done, building up our reputation in the state and regionally, has borne fruit. Just as Jawad Hassan mentioned yesterday in his opening speech, we hosted the SIFOC meeting, which effectively meant 170 judges from 56 different countries coming to Doha about 3 weeks ago. And we very much see ourselves as a public service. We are seeking to build capacity in Doha by being a complementary part of the overall system. As for the constitutions, at first instance, it's my job as registrar to decide who sits on what cases, and that is usually done on the basis of experience. If it's an employment case, we have a number of judges who are particularly expert in employment matters. If there's a case that requires a deep knowledge of the GCC region and how things are done, we will obviously have a judge from that region as well. Because as good as judges from different countries are, you'll need a local judge to interpret things as they are on the ground, which foreigners simply wouldn't know. And on appeal, Lord Thomas chooses who he sits with.
Right. Thank you. Thank you, Umar. And Khurram, can you please enlighten us about the interaction between the courts? Like how does the judicial system interplay in these different countries with regard to ADR and the courts?
Sure. So I'll speak briefly on the GCC regimes. What we've seen in the last few years is there's been a very positive, on the whole, relationship between the courts and the ADR institutions. So speaking of mediation, for instance, in the UAE, UAE has been quite clear about recognizing the role of mediation. As of 2021, there's been a helpful regulation in place which recognizes contractually provided for mediation. And then beyond that, the courts have also carved out certain cases that the judges are able to refer to mediation. Bahrain has had similar levels of progress. There's a 2022 decision which has been quite positive in that regard. And I think that's generally the case for the region. In the case of negotiation, that's also a mechanism that's frequently used. One point of caution for a lot of practitioners has been that traditionally across the GCC, the concept of without prejudice, or otherwise described as settlement discussions only, has not existed. And so parties that have been trying to negotiate an amicable resolution have been somewhat concerned about the types of points that they discuss in writing, or the quantum, for instance, that one party is willing to put forward. There are ways around it, or ways to at least mitigate the risk, but that's one point that I think still requires some improvement. And then on the arbitration side, in general, my impression is that the courts have been quite positive in recent years in terms of their interactions with the ADR institutions. This, I think, holds for the UAE, in my experience in Oman, in Qatar, and in Saudi as well. So, traditionally in Saudi, there were concerns that an arbitral award would be reviewed de novo by the courts, which rendered that whole procedure futile. But in recent years, there's been quite a bit of progress, and as probably many of us know, Saudi's made huge progress in the field of both domestic and international arbitration enforcement and recognition of the arbitration agreements. Thank you, Omar.
Thank you, Khurram. Coming on to Aisha. So what is your comment about, is Turkey arbitration friendly? And what is the future of international arbitration generally with regard to Turkey at the moment?
Sure. I will say the short answer is yes. Yes, Turkey is considered arbitration friendly, especially if we think about the international commercial arbitration. First of all, Turkey is an important region for international and trade and finance. Istanbul has a great potential for arbitration proceeding, especially for Turkish companies who is investing in internationally, and also international companies who is investing in Turkey. The country has greatly advanced its arbitration legislation and practice, especially after 1980s. In this respect, it has become one of the arbitration-friendly countries in the world. In addition, Istanbul is the center of the trade. It's because of its geographical location. It allows you to go many cities with a flight about like 5 hours. For example, from Karachi, there is a direct flight to Istanbul about like 5 hours. And the other reason, I will say, we have the modern arbitration legislation, the legal framework in terms of arbitration governing, including both domestic and international arbitration. The Turkish arbitration law enacted in 2001 is based on ancestral model law on international commercial arbitration, provide a familiar and predictable legal framework for parties engaged in international arbitration. The other reason, recognitions of the arbitral award, Turkey is a signatory to the New York Convention on the recognition and enforcement of foreign arbitral awards. As such, arbitral award made in other contracting states, the convention are generally recognized and enforceable in Turkey, subject to limited expectation. Also, I will add, Turkey has established arbitration institutions, facilitates the conduct of arbitration proceeding. For example, EDAC, Energy Disputes Arbitration Center, is the first and only sectoral arbitration center focused on only energy disputes and operated as an international arbitration center. EDAC consists of the secretaries and the board of directors, the national boards and the international boards, the consultants and arbitrators. Is not affiliated with any state or any organizations. It is an impartial and independent arbitration center located in Ankara, capital city in Turkey, ensuring that the arbitration process is carried out objectively and reliably. The Energy Disputes Arbitration Center is home to board members, consultants, and arbitrators from different nationalities and legal systems who are expert in the energy sectors and international law.
Thank you so much. My next question to you is, Like, how does the mediation system work in Turkey? From Pakistan, we think and believe that Turkey has done some really good work in mediation. So can you please enlighten us on what exactly is going on in mediation in Turkey?
So the mediation, so in Turkey there are two types of mediation we should mention. The first one is the optional mediation, or we can call voluntary mediation. But the other one is the conditions to the litigation mediation. So if mediation is decided as a case condition, parties filing a lawsuit without applying to a mediator will cause their cases to be rejected because of the lack of the case condition. For this reason, first of all, the parties apply to a mediation office for the mediation result. In Turkey, I should say not all cases covered by mediation. Mediation is only possible matter that the parties can decide with their free will. To put it clearly, the parties may go to mediation in matters that do not concern public order and are suitable for enforcement. Mediation is not possible in that matter. The parties cannot contract, for example, in criminal cases, in civil registration cases, and also the cases related to the custody of children. I should say Turkey has made significant progress in mediation in recent years. For example, the law on mediation entered into force in Turkey 2013. At the beginning, mediation was applied only voluntary, then it was made a condition to be file a lawsuit for labor disputes in 2018. For commercial disputes in 2019, and finally for consumer disputes in 2020, and actually recently the mediation became a mandatory for the rental disputes in 2023. Actually, in this conference, also people ask me a lot about mediation because I know you just enacted the mediation act in Pakistan. Like mediation, people are asking like mediation is a commonly used alternative dispute mechanism in your jurisdiction. Also, in terms of commercial disputes, what proportion of the commercial disputes are settled through mediation? So if you look at the recent statistics, I can say the mediation, including voluntary mediation, is becoming more common, and the mediation culture is now emerging in Turkey. Mediation is mandatory before filing a lawsuit in labor disputes in Turkey. This is like the debt and compensation claims arising from the law, individual and collective labor contract and re-employment claims. And also, since 2019, a mediation process for commercial disputes has also entered into force, with the mediation being mandatory in certain cases. With regard to commercial disputes, parties must first apply for the mediation for disputes relating to any claim for receivables and compensation in Turkish Commercial Code. Such as IP-related disputes, there is a mandatory mediation, banking and financial service disputes, disputes relating to recourse lending transactions, and disputes relating to publishing contracts, and disputes relating to business or assets, acquisitions, mergers, and reorganizations. I'm almost finishing. I just want to mention the statistic released by the Ministry of Justice recently shows that the disputes were referred to a voluntary mediation since 2013. The rate of settlement is about 99%. It is such a huge amount, and the statistic shows that the mediation really works in Turkey. The awareness of the culture of resolution in the country is increasing. The promising results suggest that the use of ADR and arbitration will also increase in the near future. thank you for your time and attention. If we're all set. Or
No,
we-
thank you so very much.
Okay.
And just a very short, quick one, Khurram. So how do you suggest the use of technology or the ADR in dispute resolution?
Sure. I don't know if this mic is working, but I'll give it a go. So I echo a lot of what Ayse has said. I think the way she's described Turkey is probably true of much of the region. I was going to say that the future for ADR across the region is very bright, but I realize that's a little self-serving. So let me just put it this way: it's here to stay. And what we see with institutions proliferating across the region, the existing institutions getting stronger, I think those are all reasons for us to keep an eye on what's going on. And what I mentioned earlier about the drivers for ADR, I think we need to keep those in mind. For those reasons, arbitration, mediation, negotiation, and some of the other forms, mechanisms will be increasingly important across the region. There's a few things that I think there's disparate impact. So for instance, I mentioned the settlement discussions and the lack of protection in some jurisdictions. That's one to keep an eye out in terms of the GCC. Also, in some jurisdictions, nuisance litigation is disincentivized for the reason of costs. In other jurisdictions, that's not in place. But I think that too will shift over time. So let me just pause here, and thanks, Shiraz.
Yep. Thank you. And the last one from you, Umar. How can the model of QIC DRC, that's really interesting for me because the International Court and the Dispute Resolution Center, you have clubbed the two together. Can this model be replicated? And when are you replicating this model in Pakistan?
The model certainly can. There are a number of those models. We are a particular one in that we are part of the national system, and I can't stress that enough. It's not the case that national judges aren't good enough or aren't trusted. It's a product that more people understand, and as I said, we have some really very good Qatari judges. We are also onshore. We are not an offshore court, which means we are again part of the national system with our own enforcement powers. There's a number of different models. You can have an offshore system, you can have only foreign judges, you can have only local judges. So countries looking to replicate this type of center have a lot of different options to choose from. Now, the final question you asked me, can it be replicated in Pakistan? I stress, it's certainly not for me to say what may or may not work here, but I can tell you is that the model we have chosen in Qatar definitely works. And it's perhaps for countries looking to recreate a similar model to see what works around the world and pick the best bits. But what you do have here is a very strong legal profession and a very sophisticated judiciary, which means that you have the base tools that you need if you wish to create something similar. Thank you.
Yeah. Thank you, Umar. And just the last quick one from Robert. Like we have got NED and NAST as knowledge partners with us today. So what do you think? What are the role of the universities is important in ADR training?
Oh, absolutely. The only way we get good ADR practitioners is by encouraging them at an early stage. So at university, when they're undertaking their law degree or indeed associated degrees, to actually understand the basics of ADR, understand how it works throughout the world and why it is important in the legal circles to have a system, an alternate system to the courts. The courts, of course, do a great job, but they're completely backed up, as I mentioned earlier. And teaching students about ADR, getting involved in ADR, and therefore becoming ADR practitioners is the only way you're going to actually then have a system that reduces that backlog in the courts, because you'll have people who can deal with it.
Yeah, thank you very much. I've got just one question. If anyone from the floor would like to ask any question from any of the panelists.
My question is for Mr. Khurram. Arbitration, we have been hearing throughout the symposium that this arbitration is a private form of dispute resolution between the parties, wherein it fits into the contracts where the consent of the parties is of paramount importance. And sufficient length of the symposium had been dedicated towards the power sector disputes, where mainly obligations and compliances are involved. Do you see arbitrability of compliances in future, Or is there any scope right now we are having, either internationally or nationally?
I think fortunately for me, I'm not best placed to answer that fully, but and I defer to the esteemed justices here and the practitioners. But I think in brief, the way that I look at it is where you have an arbitration provision that is very clear in terms of the consent, that is to say it's not pathological or doesn't have any other problems, then it would follow, given that Pakistan's a New York Convention party, or state rather, that those would be or ought to be complied with. Now, it's certainly possible that within certain regulatory circles or for arbitration provisions that have a state component, there is a different treatment of that, which I wouldn't be able to speak to. But in principle, the concept is where it's clear that the parties have consented to that mechanism, and you're dealing with a state, which we are here, that has adhered to the relevant convention, then the parties ought to be able to arbitrate that dispute.